It's a pleasure to introduce Ekaterina Mishina. It's actually a kind of second time I'm introducing Ekaterina, because those of you who attended our previous event, the Pussy Riot discussion, you already heard Ekaterina's comments on Yelena Gapova's paper. Ekaterina Mishina is a PhD lawyer. She graduated from the Law School of Moscow State University. She worked for the Constitutional Court of Russia, then headed the legal department of Mostelecom, main telecom company in Moscow. She participated in a number of prestigious projects. I will highlight just few of them. She actually was involved in the legal case of Khodorkovsky. She worked on Khodorkovsky's lawyer of his charity foundation to defend and to discuss his charity foundation. And as far as I know, it was one of the reasons why she lost her job.
Like many others did.
Like many others involved in that. Ekaterina was a visiting scholar in NYU in 1991. She also took part in the U.S. Department of State program, U.S. Russian Experts Forum. And now she is teaching, she's a visiting professor in the University of Michigan. Before I ask you to join me greeting Ekaterina, I want to tell a little bit about our next events. For the next 3 Thursdays and several days after that, we will present screening of films by the acclaimed Polish director Agnieszka Holland in anticipation of her Copernicus lecture at the Michigan Theater on October the 10th. Please mark your calendar. All events are free and open to the public, and we encourage you to take a flyer here or consult with our website to learn about the details. We are also looking for our student presentations about the travel, research in the summer and internships in the summer, partially supported by CREASE. That event will take place on Tuesday, October the 2nd at 4 p.m. in this room. And our next CREASE noon lecture speaker will be Professor Alexander Martin. He will speak on October the 3rd. He's from Notre Dame, and he will present the lecture Constructing the Enlightened Metropolis, Modernity and Backwardness in Moscow in 1762, the beginning of Catherine II's reign, through 1855, the end of Nicholas I's reign. So it's his new project, it's not his new project, it's his forthcoming book that he will present and discuss with us. He's a wonderful scholar, and we look forward to seeing him here. And now please join me in greeting Ekaterina Mishina.
Hello, everyone. Thank you very much for coming here and taking interest in my presentation. I'm especially touched that I see here some of my students. I thought my presentation would be maybe a little bit boring for them, because partially I will be talking about the things we have already discussed yesterday and the day before yesterday. But anyway, I'll try to tell you as much as I can about the problems of legal profession in the contemporary Russia. And also, though we have time for the presentation and time for questions and answers. Nevertheless, I encourage you to ask me questions. Just raise your hand and I will be very happy to answer. It won't break the idea of the presentation. I will try to remember what I was talking about. Okay, thank you. So, as you may know, Russia now is experiencing the 21st year of judicial reform in the country. It was a very big event when the concept of judicial reform was published. It was made already at the time when the Soviet Union still existed, because the day of dissolution of the Soviet Union was December 30th of 1991, and the concept of judicial reform was published in October. When the former Soviet Union and its former member republics started their transition to the market economy and the democratic society, one of the most important issues were how to adjust representatives of certain professions of the new situation. And that was especially important for the representatives of the different branches of legal profession. My presentation is based on the data which we received in the course of realization of a comprehensive 3 years project of the Ford Foundation. The project was conducted by one of the oldest and most reputable think tanks in Russia, the Indem Foundation. Another source which I used for this presentation was a book which I co-authored with a group of my students. That was a project realized by the Foundation Liberal Mission, which exists within the framework of the National Research University, the High School of Economics. And while working on this book, the name of the book was published 1 year ago, and the title was "How Does It Feel to Be a Lawyer?" The main idea was how the representatives of different generations of lawyers feel about the current status of legal profession in Russia, what pros and contras they see in the career of a lawyer, and what are the motivating factors for the students when they decided to become lawyers, because they know all challenges, all complications, and all risks which being a lawyer involves now in Russia. So, when I was working on this big project in the Indem Foundation, I worked with two very famous and very bright sociologists, Georgy Satarov and Vladimir Rimsky, and they trained me very well, and what I learned from them was a theory of path dependence of the institutes from their past. In a nutshell, it may be said like it's history matters. History really matters. And what's happening now with the lawyers, it's also part of the history of the profession. So now let me briefly describe you what was the status of legal education and a legal profession in the Soviet Union and what's happening now. Legal education was very good in the pre-revolutionary Russia. There were 13 universities with law schools, and the students were bright, the professors were really good. But after the October Revolution of 1917, most of the law professors tried to escape from the nightmares of the new regime. Some were killed, but luckily a group of lawyers remained in the country and agreed to cooperate with the new government. And that was the founding network of the future Soviet legal education, because the main purpose was training of trainers. The country, after the Great October Revolution, first found itself under deep influence of the ideas of Marx and Lenin, who were proclaiming in their works that such institutes as state, law, family, and other important social institutes would be needed only for the time of transition from capitalism to socialism, and after the victory of socialism in the Soviet Union, these institutions won't be needed and they will just wither away. So for the transitional period from capitalism to socialism, it was absolutely necessary to set up a system of Soviet legal education. In order to do that, and the famous Institute of Red Professors was created in 1921. Let me show you some information about that. As you understand, the initial purpose of this institute was to train trainers in the area of social science. We can perceive Bolsheviks as terrible people, but nevertheless they had some common sense and some sense of humor, and they understood that that would be a bad idea to train trainers, real Soviet professors in the area of physics, mathematics, chemistry, and other complicated sciences, because most of the students of this Institute of Red Professors hardly completed elementary school before becoming students of the Institute of Red Professors. The institute existed until the end of 30s, and it was providing education for the trainers in certain areas of social science, and in 1931 it was divided into 10 separate institutes. Luckily, in the mid-40s, the system of Soviet new legal education, not training of Red Professors, but the system of legal education was restarted. Even more luck they had, because some professors who taught in the pre-revolutionary law schools in the universities were still alive and still wanted to cooperate with the new regime. So the system was working again. And by the beginning of 50s, a new generation of new Soviet lawyers was trained, and some of them became really great lawyers, some of them became clones of these Red Professors, but that's how life is. Speaking about other representatives of legal profession, I must emphasize that the most scary branch of the legal profession was and still is the procuracy, the eye of the Tsar. Those of you who read history must know that the procuracy was founded by Tsar Peter the Great. It was a very important state body. In the course of the October Revolution, it was liquidated, but very soon Bolsheviks felt the necessity of the eye of the Tsar, even under the Soviet regime. So it was restored, and slowly but steady, it acquired an enormous power. And after the Second World War, which is in Russia is called Great Patriotic War, the procuracy enjoyed unlimited power and de facto was subordinated only to the bodies of the Communist Party. The most exciting part of the competence of the procuracy was that it combined the function of preliminary investigation and the function of supervision over preliminary investigation. That was really misleading, but the point is that the procuracy stayed on this track until 2007, when at last the investigatory committee was created within the system of the general procuracy. Now the procuracy still is a very mighty organization, strongly disliked by most of the representatives of laymen, and also procuracy is not very popular among lawyers. Even under the Soviet rule, a profession of a prosecutor was not in high demand. Initially, it had some romantic attraction for those who wanted to fight criminals, who wanted to be very important heroes of the revolution, but it all disappeared after it became clear what was the main purpose of the prosecutors in the realization of the ideology of the Soviet regime. And still, the procuracy and the prosecutors are not popular, and the results of sociological studies and in-depth interviews which we conducted in terms of this project in the Indem Foundation demonstrated a very bad attitude towards procuracy. Speaking about in-house lawyers, I must emphasize that in the time of the Soviet Union, being an in-house lawyer meant a very, very boring life without enough money. But some people chose this life because it meant stability, it meant predictability of the future. But now, being an in-house lawyer is pretty different. But it involves higher risks. If you remember the case of Svetlana Bakhmina, the lady who was deputy chair of the legal department of Yukos, or Vasily Aleksanyan, who was deputy head of Yukos in charge of legal issues, they both worked as in-house lawyers. And they both became hostages of the situation with Mikhail Khodorkovsky and Platon Lebedev. But these are high-profile cases known for everyone. If we take some kind of unknown in-house lawyer who works for a private company, you must understand that now these lawyers are in a very tricky position because the importance of law and the importance of compliance with the requirements of the current legislation is not fashionable now, not because people are so fond of breaking the law now. According to current Russian legislation, and please, Bill, correct me if I'm wrong, it's almost impossible to do honest business in Russia without violation of law, because there are so many prohibitions, requirements, problematic issues that a really honest businessman who is starting his own business and wants to comply with all the requirements will drown in all this paperwork and documents he needs to obtain in order to open a small restaurant. Yes, please.
Professor, who are the authors that promulgate all these bureaucratic rules and regulations?
Thank you for your wonderful questions. I also want to meet these people. Unfortunately, Russian copyright law never unveils the authorship of legislative acts. Otherwise, I would be very flattered to meet with the authors of certain legislative acts. Speaking about secondary legislation, it's also complicated to figure out who were the author, but if we try to think logically, If we have an instruction of the Ministry of Health, then that should be developed by the legal department of the Ministry of Health. That's the pure logic of how these documents appear. Another problem, which is very important for the in-house lawyers now, is that they are demanded to combine two complicated tasks. First, to secure the safety of the company and to secure the profits of the company. And usually these two tasks cannot go together, especially in the area when the internal documentation of the company is concerned, because from the Soviet times, in certain organizations and enterprises, not in all of them, but in certain organizations, and I happen to work in one of such organizations, there was a rule that an in-house lawyer is here only for the litigation purposes. We will never show this lawyer contracts, draft contracts, other paperwork, unless it's necessary to go to court. The simple idea that if you guys show the in-house lawyer the contracts, the draft contracts, then maybe it won't be necessary to go to court. Such an idea very rarely arose in the minds of the bosses of the Soviet enterprises. And the situation is pretty much the same in many places even now, because the main purpose of in-house lawyer is litigation. Because if a brand new lawyer just from the law school comes to an interview and his possible employer asks, "So, Vasya, what is your main goal in life?" Vasya answers, "My main goal is to secure the compliance with all the rules and regulations of the Russian legislation in force." The possible employer says, "Vasya, goodbye," and he never wants to see Vasya again because he doesn't need such an in-house lawyer. A real good in-house lawyer must know how to avoid the requirements, how to smooth the way of doing business of his company. And that is why most of the in-house lawyers of such companies, which openly play by these unfair rules, find themselves in a situation of double dependence. On one side, they depend on the requirements of their own profession. They are lawyers. They must secure the legality of operation of their companies. On the other hand, they must secure the success of their company. Otherwise, they will lose their jobs. That is why mission of in-house lawyers in certain enterprises in Russia even now is still unclear. I want to make before switching to judges, I want to make a point of one of the least popular in the Soviet times branch of the legal profession, to notaries. Unlike prosecutors, unlike judges, unlike even public attorneys, notaries feel much better now than they did in the Soviet Union. In the Soviet Union, of course, there were no private notaries in the country. There was only a public system of notaries, and people spent their lives waiting for an appointment at the notaries because lines were enormous. In the beginning of 90s, a wonderful young lawyer named Anatoly Tikhenko, and certainly some of his friends started a campaign for introducing the principles of private notaries in the Russian Federation. In 1993, Russia became a member of the International Union of Latin Notaries, and the Institute of Private Notaries was introduced in the Russian Federation. And that was a big success. Notaries clearly demonstrate that they can be very good representatives of legal profession, because now there are almost no lines for notaries, and unlike public notaries, private notaries are responsible for the quality of what they are doing, and they bear financial responsibility for the quality of their actions. Unfortunately, no good deed goes unpunished when this wonderful notary Anatoly Tikhenko got involved too deeply into the situation with the real estate in the city of Moscow and in the area of Moscow. He was assassinated in February of 2001, but what he created was a wonderful thing named public notaries in the Russian Federation, private notaries in the Russian Federation. Okay, now we come to the most exciting point, because everyone knows about Russian judges, how wonderful, reliable, and independent they are. So let's get into details of their high quality and reliability and independence. I'll try to hit the right button. Yes. Okay. Like other branches of the legal profession, judges in the Soviet Union didn't enjoy good status. The system of courts was abolished in the course of the October Revolution, but very soon recreated in a new way. One of the first acts of the new Bolshevik government was the Decree on Courts number 1, issued in November of 1917, and it introduced people courts, which went together with the so-called revolutionary tribunals and emergency committees of the state security agencies. Please note that at that time, judges, real new Soviet judges, were not required to be guided by the norms of law. They had to base their judgments on revolutionary legal conscience. Even more, Vladimir Lenin, in one of his works openly encouraged the new Soviet judges not only to use the methods of terror in so-called administration of justice, but also to give the methods of terror the legality, to make it the fundamental principle of administration of revolutionary justice. You know that principle of separation of power is not compatible with the totalitarian state, and the Soviet Union was a totalitarian state, so of course there was not independent judiciary, there were not independent judges, but unfortunately bad habits die hard. And many of the problems the Russian judiciary has now relate to their past. One of the problems relates to the so-called Soviet judicial mentality. What's Soviet judicial mentality? First, Soviet judicial mentality means that judges don't feel like independent arbitrators. They feel and act as if they were governmental officials. Another point is accusatory or prosecutorial bias of the Russian judges. Most of the Russian judges and the Soviet judges are former prosecutors, investigators, militiamen, officials of the law enforcement system. And most of them keep the old patterns in their new activity after they have become judges. Another important feature of the Soviet judicial mentality is the impact of the previous career, because new judges are trying to use the mode of operations they were used to employ as prosecutors and investigators in their new career. So here you may see the list of most pressing problems of the courts and judges in the Soviet Union. Here I would like to highlight the enormous power of chairpersons of the court. This problem was, still is, and I'm afraid will persist for a number of years, because a lot of attempts were made in order to diminish the scope of power of chairpersons of the courts, but nothing was really done. On the contrary, in certain areas, their scope of powers is getting bigger. I don't want to look so pessimistic, because there were some real achievements of the judicial reform in the Russian Federation. Nothing was so bad and negative. And one of the most important achievements was the real increase of the salaries of judges, because like in-house lawyers in the Soviet Union, judges were also very underpaid, and a judicial position was one of the least sought after branches of the legal profession in the Soviet Union. Now, judges in the Russian Federation enjoy a really good salary. Also, there was some progress in the area of execution of judgments. That was a vulnerable area for a long period of time. And of course, establishment of constitutional justice initially looked very hopeful. But let me disappoint you, de facto judiciary still is not independent, though the institutional design, the institutional judicial independence looks good. There are good laws. The problem is that they almost are not working. Another problem was caused by passing on 3 new procedural codes. Some people even called it procedural revolution of the beginning of the 21st century in Russia, because it was especially important in the case of the Code of Criminal Procedure. Application of very good norms of the Code of Criminal Procedure brought up really unexpected results. Another disappointment was the evolution of the Constitutional Court, which initially was operating from time to time, not all the time, but occasionally it was operating as a really independent institution, and the top of its independence was reached during the October crisis of 1993, when President Yeltsin decided to dissolve the Parliament of Russia. But now the Constitutional Court is losing its prestige and reputation, and like many other courts, is becoming a political tool. Reintroducing of jury trials in Russia I'm sure you know that there were jury trials in the Tsarist Russia, which appeared in the course of reforms of Alexander II after 1864. But the reintroducing of jury trials in Russia was also very promising, and we had a lot of expectations related to it. Unfortunately, there are many problems related to the jury trials. First, people don't want to serve as jurors. They are not motivated. Jurors are scared. Jurors very often become objects of external impact. And the most important point, the competence of jury trials is getting more and more narrow. Unfortunately, despite numerous publications in this area, despite the slogans of the government that we need judicial reform, we need really good independent judges, of course, there are good judges in Russia. Not all the judges are bad, but unfortunately, there are many judges which keep prosecutorial bias in their activity and who lack decisional independence. They don't feel the necessity of being independent because they have this very good genetic memory of the Soviet times when judges were very well manipulated and dependent on the procuracy, on the Ministry of Justice, on the bodies of the Communist Party, on the administrative agencies, on the upper courts, on the chairpersons of the courts. This multiplied dependence was killing the very idea of decisional independence of the Soviet judges. And some of them are still there. What are some lawyers, especially, and there is nothing bad in unveiling the names, a group of lawyers, including the famous lawyer Sergei Pashin and ex-deputy chairman of the Constitutional Court Tamara Morshikova, are talking about judicial counter-reform in the Russian Federation, which is also a sign of the presence of some crisis in the legal profession. The last judge, the only judge who was elected and not appointed on the top of judiciary in Russia until May 2010 was the Chief Justice of the Constitutional Court. It was elected usually for 2 year terms by his colleagues by a secret ballot. Since that time, the Chief Justice of the Constitutional Court is not elected anymore. Like other top justices, the Chief Justice is appointment. Another sign of a counter-reform in the area of judiciary is the continuing limitation of the jurisdiction of jury trials. Step by step, more and more, we are getting evidence that courts are becoming real political tools. We were discussing the case of these young ladies from the bank group a week ago, and the behavior of a judge that was really controversial and deserves a lot of comments. But unfortunately, we have many examples when courts are used as political tools. And further increase of the roles of the chairpersons also demonstrates that something is really wrong with the judicial reform in the Russian Federation. And how much time do I have? Nothing.
10 more minutes.
10 more minutes. Okay, thank you very much. So now let's talk about attorneys. Let's talk about defense attorneys. The Institute of Independent Attorneys appeared in the pre-revolutionary Russia after the reforms of Alexander II. That was the time when the Independent Bar Association was created and the jury trials were introduced. And moreover, some of the defense attorneys of that time became really popular. You know, representatives of the legal profession are not very popular among other professions in Russia. I cannot say that lawyers are very much liked. Some of them really are, but not all of them. But speaking about these defense lawyers, they became celebrities due to their devotion to the defense of rights and individual and liberties of ordinary people, due to their eloquency, due to their outstanding public speaking skills. These lawyers, these defense attorneys were even more popular than actors. And that was really a big achievement in terms of development of prestige of legal profession in the pre-revolutionary Russia. Of course, everything was liquidated in the course of the October Revolution of 1917. These good defense attorneys were not needed. Like in a year after the revolution, there was a decree introducing the system according to which any man or woman who has a letter of recommendation from the local Soviet of People's Representatives can become either a prosecutor or an attorney and act like one. This system didn't last for long, and the official year of setting up of the Soviet Bar Association was 1922, but creation of the Soviet Bar Association and passing on of the 3 statutes of the Bar Association was nothing but a window dressing, because defense attorneys were not needed in the time of industrialization, collectivization. They were not especially needed in the times of the Great Purge. The criminal procedure of that time didn't involve defense attorneys as procedural figures de facto. Of course, defense attorneys had a lot of things to do in the realm of civil proceedings. But luckily, the situation changed in the late 50s, early 60s, and the Bar Association was developing. And in accordance with, and comparing with other branches of legal profession, the defense attorneys enjoyed more autonomy. I cannot say independence, because there was no place for independence under the Soviet rule. They enjoyed more autonomy. What's the problem with the defense attorneys now? There are some brilliant attorneys, very good lawyers, highly professional, which have a wonderful skills of public speaking. But everyone knows that these lawyers are really very good public speakers, but in terms of their professional capacities, they are the so-called people who solve the problems. They don't provide legal aid. What they are doing is completely illegal. Though these lawyers are popular, there are also very good defense lawyers who enjoy wonderful reputation. And you know these lawyers, at least I presume that you know these lawyers. But unfortunately, the rules of the game, especially now, during the last 2 years are very unpleasant. Some defense attorneys don't act as defense attorneys. They act like people who solve the problems with the help of money or rendering services. And another problematic area with the defense attorneys now is higher risks. Where do these high risks come from? Of course, logically, they can come from their clients, especially in the realm of criminal procedure, but usually it doesn't happen. More serious risks are coming from the part of the state, because there were several attempts to subpoena defense attorneys as witnesses. Because, these guys in the general procuracy, they have a very special knowledge of law. I remember I enjoyed the public speech of Deputy General Prosecutor Vladimir Kolesnikov. That was 10 years ago. He was speaking in the State Duma, and that was the time when the preliminary investigation of the cases of Khodorkovsky and Lebedev was going on. And Vladimir Kolesnikov was speaking in the State Duma, it's the lower chamber of the Federal Parliament of Russia, and he was asked a question about the possible punishment which Khodorkovsky and Lebedev can get. And he said, very seriously, because this guy doesn't have a sense of humor, I tell you. He said, unfortunately, we cannot give him more than 10 years. And smiled sadly. That was unthinkable, because I presume that every lawyer must know that it's not his business, it's not a prosecutor's business to decide the questions of guilt. It's the competence of a court. But he said it openly, and it was it was on TV for like 3 or 4 days, and we're enjoying it, and that was really unthinkable. So these nice guys from the General Procuracy, from time to time, they are trying to subpoena or even arrest the defense attorneys. And to be a defense attorney means to lead a risky and dangerous life, and even to be prepared to escape from the country, like many of them did, like did Anton Drel, Boris Kuznetsov, Pavel Ivlev, and many others, because they didn't want to wait until they would be arrested and something would happen with their families. Luckily, the current Russian legislation provides no legal grounds for arresting a member of the bar. Before arresting, the state has to reach the point when this defense attorney will be deprived of this status. But it takes some time, and usually the top figures of the Russian bar are strongly against it. So being a defense attorney is risky, involves a lot of temptations. Some of the defense attorneys are not real defense attorneys, but more like people who solve problems. And summing up my presentation, I would like to emphasize several points. What we have now in legal profession is the result of the demand for lawyers, which we have now in our country. The problem is that the democratic movement of Russia was a movement from the totalitarian state to the authoritarian state. it's better, but it's not okay, you know. So the only the only basic difference is the presence of market economy. But the presence of market economy doesn't mean that all the constitutionally provided rights and liberties are really existing in the day-by-day life of the country. Now, by the way, do you know this one? Did I tell you this wonderful joke about the difference of the Russian Constitution, the American Constitution? I really love it. When I say it was not the Russian Constitution, it was the Soviet Constitution of 1936. The Soviet Constitution of 1936 provided for freedom of mass meetings, demonstrations. And the Constitution of the United States provides for the freedom after demonstrations and mass meetings. So that's what's happening now in the country. So yeah, it's funny, but not for us. So speaking about the demand for lawyers, now I want to emphasize that the mission of a lawyer now is different, even in comparison with what it was under the Soviet Union. In the Soviet Union, we had less areas of possible involvement of lawyers. Now, due to the transition to the market economy, the legal system is developing. And of course, there are new temptations, new complications, new hardships. But all the signs of crisis in a legal profession are mainly connected with two circumstances. First, the strong persistence of the problems inherited from the Soviet past, and second, law demand for real lawyers who have the high mission of securing the compliance with the requirements of the current legislation. So thank you very much, and if you have questions, I would be happy to answer.